Good morning, everyone. Today is August 31st. I'm Denise McCarthy from Cody and McCarthy, and I have with me here today attorney Shawnee Collymore and attorney Emily Esch. And we're here for the last segment of our summer educational series, which is about probate, which is, I know, something a lot of people ask us a lot of questions about. Number one concern, I think, when a lot of folks come in for estate planning is, how do I get the heck out of probate? Either they've heard stories from people, or they've just settled their parents' estates or been exposed to other people that have suffered through that process. I'm here to tell you that Emily is going to give you a fantastic presentation on how you can avoid probate. And for some people, they're not that worried about avoiding probate, but if they are going to go through the probate court process, how do we smooth it out and make it as simple as possible? Both Shawnee and Emily are wonderful attorneys who focus a lot on estate administration, and will hopefully give you guys some really great advice here. And one thing I wanted to mention to folks is that we are still offering complimentary consultations. So I'll put in our contact information in the chat function, which is where you can also submit questions to us if you have them throughout the presentation. And we are able right now through December 15th, I believe is the date, we lose our ability to virtually notarize. So what that means for you is we can actually start and finish your entire estate plan virtually, which is not something we're typically able to do because we cannot notarize documents virtually, but because of COVID, we've got this temporary legislation in place. So anybody that's been thinking this is something you need to get done and haven't done it yet, this is really a great time to do it, because you don't have to, worry as much about scheduling and dealing with traffic and all of those issues that make it easier for us to procrastinate. So thank you so much for joining us this morning. Without further ado, I'm going to kick things over to Emily, who will talk you through probate.
Thank you, Denise. All right, let me get my screen up here for you guys.
And I should mention that we are recording the presentation, but none of you are visible or audible, so you don't need to worry about.
So just switch your screens, Emily. So you go to display, yeah, and switch to the other screen.
There we go. You guys have the slide in front of you?
Yep.
Yes. All right. Thank you, Denise. And again, welcome to our final summer education series. Today is all about avoiding and simplifying probate. So to start things off, I want to start off by explaining what probate is. So from a very base level, probate is the process through which someone who's passed away, their assets are administered. And it's done through the probate court in whatever county that person resided in. If there's a will, the court makes sure that the decedent's assets are administered according to the wishes of the decedent's will. If there's not a will, then the court makes sure that everything gets distributed to the correct heirs at law. The court also appoints what's called a personal representative. This is a newer term in Massachusetts. It is in other states, and previously in Massachusetts, it was known as executor. So executor and personal representative can be used interchangeably. The court also determines the heirs and beneficiaries, and also can settle disputes and disagreements between family members. So when is probate necessary? Probate is necessary when someone who's passed away, the decedent, has assets that are in their name alone. So this means that the assets are not in a trust, there is not a named beneficiary, there's not a transfer on death designation, and there's not a joint owner. So we have some examples over here on the screen that things such as a safety deposit box, a vehicle can't have two, doesn't have two names on it typically, real estate in someone's name alone. Those are the types of assets that typically need to go through the probate process. So in Massachusetts, we have multiple forms of probate. The three main forms are formal, informal, and voluntary. And I'm going to go through each rather quickly, but just to give you an explanation of what each type is. So first we have formal probate. This is the longest and the most expensive process. It's a minimum of 90 days before someone is appointed as personal representative or executor typically. It is always required if there is no original will, and it's sometimes required if there is real estate in the estate. The next type is informal. This is a little bit of a quicker process. You have to have the original will in hand to be able to do informal process. And because it's a bit quicker, it's also more cost effective. Then we have voluntary probate. Voluntary probate is only an option when the decedent's assets in the estate are $25,000 or less, exclusive of one motor vehicle. So the nice thing about exclusive of one motor vehicle is that, you know, your grandpa could have a nice, midlife crisis BMW convertible that's worth more than $25,000. But as long as there's not more than $25,000 of other assets, voluntary is still an option. It is the quickest and the most effective option, cost effective, excuse me.
Emily, can I ask a question about that? If you go just back to that slide. So say you and Shani have a new case that comes in, someone has passed away. How do you make the determination between formal and informal? Like, what are you guys looking for to decide?
So first we're going to sit down with the client and we're going to see, first of all, is there an original will? If there's not an original will, then formal probate is absolutely required. If there is an original will, then we can talk about the option for informal. Also, if there's a lot of family contention, a lot of times it's we recommend doing formal probate, because then you get the court determination and oversight of everything, and it leaves the door to liability is not as wide as it might be without that judicial oversight.
So you're saying if you've got contesting siblings, family members, they're better protected in serving as personal representative by having gone through the formal process.
Yes.
And
Shani, did you have any comment on that?
Yeah, I just want to say another major reason that you might want to do formal is if you have real estate, especially if you have real estate that's going to be inherited by a beneficiary. The only way, because to get good title for the property is to have a formal determination of heirs, and then to like officially close out the estate with the court. So you need to kind of go through that process for if you're going to have good title to real estate, and it's not going to be sold like dirt by the personal representative. So that could be another determination why you might want to do that. So it depends on a lot of factors.
I agree. I think what's interesting is they actually in 2012 is when we got a whole new probate system, and it was touted as designed to make things easier for the average person. And what it's kind of evolved to is, okay, right out of the gate, as you're trying to do this on your own, you have to decide between formal, informal, and voluntary, which would take, hours and hours of research to just figure out what those are, and then try to layer on this analysis of which one is most appropriate for you. Unfortunately, I still feel like the probate process really requires an attorney to assist a person going through
Yeah.
it. Unless maybe there's just a car. I think you probably both agree with that, right?
Absolutely, yes.
Right, sorry to interrupt, carry on.
No, thank you. Those are good questions. All right, so what happens, we already went over this briefly, but what happens if there's not a will? So we have either formal or informal probate is required. Assets go to what's called the heirs at law. So this is determined by state statute, meaning there's rules on the book that says who your heirs at law are, right? You're like your spouse, your kids, your siblings, that type of thing. It is the longest and most costly. If there is a will, we can do formal or informal, like we just talked about. Let's see. And what's nice about having that will is that the will gets to dictate who gets what. All right, so I'll walk you through the formal proceedings briefly here. So first of all, for formal probate, you can file at any time after the person has passed away within a 3-year timeline. If it's been more than 3 years, then there's a special proceeding called late and limited formal probate, but that typically that's not done as frequently. So we're going to just focus on the 3 types here today. So first we file the petition, then a citation is issued by the court. A citation is a legal way of giving notice to interested people, and it has to be published in the newspaper of the court's choosing at least 30 days before you can go back and say, I published it like you said, court. So that's the service of the citation. And then all the heirs and interested deservees, everyone who's interested in the estate assets gets that same citation, but by a mailing. Then
and sorry, just interrupt. And just so I want to make sure people understand this is while all of these statutory waiting periods are going on, what that means practically for you as the person who initiated probate is that you have no access to the assets in the estate of the person that has passed away, because right now all of what Emily is talking about is this process that is leading up to you getting appointed as personal representative or executor. Up until then, you don't have access. So all of this kind of waiting game that she's talking about is really causing a delay in your ability to administer the estate.
Right. I always tell my clients from the get-go that it's a minimum of 60 days, but with COVID still happening, the courts are still really bogged down, and really it's been more like 90 days minimum before anyone can get access to assets. So that's definitely one of the downfalls of probate.
Yeah, and COVID is, I feel like, an extreme example of the courts getting super backed up, and it was mostly because they were actually in the process of trying to shift online, and then they all got kicked to work from home, and then only some people could come in, so there's understaffed. But what it does highlight is the fact that whenever you're talking about probate court, remember that the probate court does guardianships, it does all divorces, family law. That's a big caseload, right? So it's just a very busy court. So you're always at the mercy of whatever it is that could be jamming up that entire system. Because obviously they have to, block and tackle and prioritize. And so we're always at the mercy of, 60 days to me in probate to get appointed is speedy and a real win. We're just not often that lucky. Sometimes it is luck, I feel like. The probate
Yeah,
court.
sometimes it is.
Yes. Okay. So once everyone gets notice of your intent to be appointed as the personal representative or executor, if no one contests, meaning that, no family member has said, no, I don't think that, say Denise should be, her sister's representative, it should be the cousin, that's the type of objection. As long as there's no objection, then it can be allowed by the magistrate without having to go before a judge or have a hearing. Once it's been allowed, then letters are issued, and the letters are what's called letters of authority. This is an official court document that has the seal of the court, and it confers the authority to deal with the decedent's assets upon the court-appointed personal representative. Now, the probate process takes a minimum of 1 year, and this is because creditors have 1 year from the date of death to come forward and make a claim against the estate for payment of debts owed. So all formal and informal probate are, at least you're looking at a minimum of 1 year. It's not a short process, and there's a lot of small details that are involved. So just some elements for formal proceedings. We have a statute of limitations that we just talked about, that creditors have to make a claim within 1 year. If there's not a will, there is a state statute that dictates who gets appointment. So there's a priority of appointment that does determine who gets to be the personal representative. If the will is valid, then the court makes a determination of testacy. This means that the court determines that the will is valid and that it will be followed in the disposition of the decedent's assets.
Can I pause you for just one more second? I think that is so important, because right now we give presentations virtually, but when we used to give them in person, there was always this like shock in the room when I would tell people that with a will, you go through a probate court process, because I think people miss the part that probate is either dealing with the people that didn't have a chance to or never got around to putting together a will, but then it's also validating wills, because wills are really just instructions for what you want to have happen when you pass away, but they're the instructions of a deceased person who isn't here to verify that this is in fact what they wanted to have happen. And no one pressured or influenced me or made me do it. We're just looking at what has been reduced to paper, and therefore the court wants to have this whole process to authenticate that will before we let the personal representative move forward in carrying out those wishes. So sometimes people are like, well, I just don't get it. If I wrote down my instructions, why are we going through probate? But that's the reason why you're still going through that process.
Right. So that the court makes sure that your wishes are followed, even though they're written down. So if the person who passed away did not have a will, then it's called intestacy. In either case, if they had a will or didn't, the court makes a determination of the heirs. This is also goes back to what Shawnee said earlier about getting good title for land. A determination of the heirs must be made for that. If you file formal probate after someone has filed an informal probate, maybe because you want to argue it or validate it, or for whatever reason, it stops the magistrate's ability to act on any informal proceeding. And it also stops the personal representative's authority to distribute. And it can to distribute assets, and it can stop the personal representative's authority to act on behalf of this estate, just depending on the type of proceeding that's filed.
And there is, I think it was probably a little bit too much to go into in the context of this presentation, but there are mechanisms for requesting speedier appointments through the court. We call them appointment of special personal representative, and there are mechanisms for doing that. So if you're sitting here thinking, oh, how's this possible? I'm gonna have to sell the property right away, or I can't pay for the funeral, or I can't pay for XYZ expenses. These are real problems with probate, because you don't have access to assets, and the mechanisms for requesting special appointments are like next to impossible. I think Emily, you and I worked on one this year where it took so long to even hear back on the rush appointment that it ended up being faster to have just done the regular one. So thankfully we had both those processes going at the same time. But your idea of what an emergency is not the same as what the court's idea of an emergency is. So and it changes, it evolves. So for instance, real estate. So maybe a year or two ago, if you were going to try to sell real estate, you had a purchase and sale agreement in hand, and you said, oh, I got to rush my appointment. They might hear you out on that. Now they I think turned you away, right, Emily? What did they say to you?
They said that the market is so hot right now that it will not be a detriment to the estate to have to wait, that they would get another offer. And yeah, that was not
no client likes to hear that. So but we'll go into some of that and how to avoid some of that later in the presentation.
All right, so the second form of probate proceedings is called informal probate. So as the title suggests, it is a little bit less formal than the formal probate. You can have a little bit less court supervision with informal probate. So here, if you don't have a will, it can appoint a personal representative executor. With a will, we can probate that will, probate a will, and appoint a representative. So there's a couple different options. So it's instead of being more formal, like I said, it's an administrative hearing. First, unlike formal where you give notice after it's filed, you have to give notice to the interested parties 7 days before filing. So then we file the petition, which is a nice packet, and you can file that as soon as 7 days after death. And then if it's allowed by the magistrate, then you are required to publish after it's allowed. And by publish, we mean publish in the newspaper. But here, instead of informal probate where you had to publish first and then wait and then be appointed, here you get appointed and then you publish in the newspaper afterwards. So it just cuts down on the time on the time delay between filing and actually getting your letters of authority and being able to access assets. So let's talk about what a personal representative is, because it's not an everyday terminology, right? So the personal representative or executor is first and foremost appointed by the decedent's will, or if there's not a will, or the person who was appointed in the will declines or is unable to serve, then the court will determine it via priority, which is that state statute. So the personal representative in the will is named in the will is tasked with settling the estate. This is typically first the spouse, the surviving spouse, or a des-a-vis. A des-a-vis is someone who is named in the will to receive assets. And then if there's not the will, then it's the heirs at law. So heirs at law, again, are determined by that state statute. If none of the above are available, then a public administrator will be appointed by the court. Some things to keep in mind is that even if, say, you're the surviving spouse and you just are not up to the task of dealing with all the paperwork or dealing with the disposing of the estate's assets, you can decline to serve. This is called renouncing to serve as personal representative. And then if you were named, meaning appointed in the will, then you can actually nominate someone else. So say you're the surviving spouse and you're not up to it, but you still would like to be able to say who you want to have serve. You could appoint, your son or daughter. You could appoint another family member or a person of your choosing and nominate them. And then the court would either approve or disapprove of your nomination. So then the third and final one for today's is voluntary administration. Voluntary administration, like I said at the get-go, is the most cost-effective and quickest way to access a decedent's assets, but there are the limitations. We'll go through them below here. So first of all, the statute of limitations doesn't apply. So this means that the time that creditors have to come forward hasn't started to toll. And then also you can file for voluntary administration. It's at any time. Also, statute of priority does not apply here. So this means that anyone who has an interest in the estate can come forward and apply to have the authority to access the decedent's estate assets. For voluntary administration, the decedent cannot own real estate in their own name for voluntary. If you have real estate in your own name at the time of death, that requires the formal probate proceeding. They also, as we stated before, have to have a total estate asset net worth of $25,000 or less, exclusive of one vehicle. They have to be a resident of Massachusetts, and the person, again, who is filing this voluntary administration doesn't have to be named in the will, but it does have to be an interested person. So then what you guys all came for, how can we avoid probate? So as you can see, the three different types of probate, it's quite a process. It can be lengthy. And if you're able to avoid it, that's great. Some ways that we can avoid it is first and foremost to transfer your assets into trust. You can transfer almost anything into trust, exclusive of a vehicle. So you can transfer your home, your real estate, your bank accounts, any types of those assets that have your name on it can be transferred into your trust. Another way to avoid probate is to have a named beneficiary or transfer on death designation for every single account. So
before we get into that one, maybe Shani could explain just what is a trust and mechanically how assets avoid the probate process with a trust, just so that we're all clear on that.
Yeah, so a trust is a vehicle that can hold title to your assets. Like some of you might already have a revocable trust with a spouse, something like that. A trust would name a trustee that's the legal owner of the property. And then it will have beneficiaries that are the people that are entitled to the assets. A very standard thing to do is to do a revocable trust. Like if I created one for myself, I would be the initial trustee while I was alive, and the trust would say that all of the trust assets are held for my benefit while I was alive. Then it would outline who's going to inherit the property upon my death. And typically it'll say my children And that's a very typical way to avoid probate. The only way the trust is going to actually work, though, to avoid probate is if you ensure that you fund the trust upon creation. So if you own a house, doing a new deed, putting the house into the name of your trust instead of your sole name. And if you have bank accounts, opening a bank account in the name of the trust, or making the bank account transfer on death to automatically go to the trust. So that way you don't have probate assets, because the whole point of a revocable trust is to avoid probate. So you have to make sure that it's funded properly. So it can just be a very easy and seamless way for you to transfer assets to your children or whoever your beneficiaries are. And it's also can be really great if you become incapacitated, because the trust will outline who's going to be the next in line trustee that steps in if I become sick and I can't manage my assets anymore. Maybe Denise is going to become the trustee, and then she'll take over and manage the trust for me for my benefit. So it can be really great, but you have to fund it.
Yeah, funding it is
That's the biggest downfall that I think we see.
I think sometimes people just miss that okay,
yeah,
you go through this exercise setting up the trust and you didn't actually transfer the ownership of your bank accounts.
Right. Then you still have to go through probate, which is the whole reason to do a revocable trust is to avoid probate. So if you don't fund it, it's just like a waste of money, basically.
Yeah, I mean, there are other reasons people will choose trust because of there's estate tax savings within trusts for married couples.
Yeah.
And then sometimes people are concerned about kids with special needs, or just protecting the inheritance for the kids from divorce and creditors and things like that. But primarily, avoiding probate is a huge benefit of the trust, and one of the big reasons people do choose that. Right. So really a trust is like a replacement for a will.
Yes.
It's also a set of instructions. You're just creating an entity that survives you, because I think Emily's made very clear when you're talking about probate, you're talking about transferring the assets of someone who is deceased. With the trust, you've basically created this entity that while you're alive, you can own and control it, but it is separate from you. So when you die, it still exists. So now it can distribute pursuant to your instructions. So that's kind of the trick to how you're getting out of probate, is you already moved everything while you're alive. Mm-hmm. Now the trust will make distributions versus transferring from a deceased person to someone new. So that's how the trust kind of bridges that gap. I think that's important to understand, because that does help so many people avoid probate.
Yeah.
Right. Yeah. So go ahead with transfer on death designations, because that's a great way to avoid probate too.
Well, I just wanted to bring up one other thing, is that when someone passes away, their power of attorney passes away with them. Mm-hmm. So even if you are power of attorney on your parents' bank account, as soon as they pass away, that power of attorney is null and void. And if it doesn't have one of these options, if it's not in trust, if it doesn't have a named beneficiary or transfer on death designation or co-owner, then it is going to have to go through the probate process. And I find that that's a stumbling block, that many people don't realize that power of attorney passes away with their loved one.
Yeah, that's a great point, because people say that to me all the time. Well, I'm mom and dad's power of attorney, so I'll just blah, blah, blah. I'm like, good luck, march down to the bank who's already been notified by Social Security that that person is deceased, that account is frozen. You're not touching it. It's a power of attorney.
So besides having the trust, you can have a named beneficiary or transfer on death designation on all of your accounts with the bank. That's fairly simple to do, but a lot of people actually don't when they go to set it up. So when they open their accounts. So if you are not going to have a trust, or you don't have a trust already, I really recommend that you make sure every single account has a transfer on death or named beneficiary. The other option is,
can I say one thing about that? Because it's actually a pet peeve of mine when people try to do this, when they do it on every single account that they own, because they're like, oh, look at me, I didn't consult with an attorney and I bypassed probate. If it's, one account, some small account, and it's a relatively small estate, then it can work fine. But what I've seen people do is say, it's almost like they're trying to create percentages of who gets what of their assets by manually setting up these accounts. Like, this one goes to my grandson, this one goes to my son, this one goes to my daughter, this one goes to her three. There's one for each of the kids. And then they're trying to manually keep the accounts equal and balanced. And I'm like, why don't you just have a will that gives percentages? Because that's what you're trying to do here. Because what people don't realize is it will cost money to settle up your affairs. There might be an estate tax due. And once you have a transfer on death designation on every single penny that you own, and now you name me as your personal representative, where the heck am I going to get the money? I'm going to have to go knocking on all these doors and say, actually, you owe me 1/8 of, this expense, and you owe me this. Try to collect money from people once it's been given to them. That is not a position you want to be putting your loved ones in. So I would say be aware that you have it as an option, but it is not a substitute for doing a full-blown estate plan.
And similar on that same vein is having your account as the co-owner, like Denise just said. So you might have to go knocking on their doors to get money to pay bills or estate tax that is due. Another issue with having a co-owner on your account is that you have to really trust that person 100%, because it gives them as much control over the accounts as you have. So we always recommend transferring your assets into trust, but those are the 3 ways that you can help to avoid probate without having to transfer everything into trust.
We actually have a question that came in that I think is good to answer right now. So the question is a trust a private document, whereas a will becomes public? So that's absolutely correct. So a trust is private. The beneficiaries will be notified that they're a beneficiary of the trust, and they can, request certain information about the trust. But if you get told you're not a beneficiary, you're not getting a copy of the trust, you're not getting a copy of the trust. Unless the person, you want to challenge the entire estate plan and go to court and say somebody pressured or made them do it that way. I suppose it could come out in that context in full-blown litigation, but 99.9% of the time, that's not the case. But then wills are, in fact, public. Someone can go to pull the file and see what it said in the will. So certainly if you are trying to keep your intentions private, like this question is asking, the trust would be the way to go.
Thank you. All right, so if we do have to go through the probate process, how is it that we can simplify it, right? Make it as easy as possible for our loved ones. So first and foremost, let's make sure that we have a will, because that gives your loved ones options, like we talked about, informal, formal. Also, a will states how you want to administer your assets to make sure that your wishes are followed, such as, my grandma's brooch is going to go to my sister Sarah, and not to me. I might be upset about this, but grandma's no longer here to deal with our fighting, and the personal representative has to give it to Sarah because that's what the will says. So it can definitely minimize family feuds. Another important thing is to make sure that your family members know your wishes ahead of time. This can help avoid a lot of confusion, consternation, possible arguments. And then also make sure that your nominated personal representative, the one that you name in your will to administer your estate, is aware and knows what your wishes are and knows what your will says, so that when the time comes for them to step into this role, that they already are secure in what they know that you wanted them to do. And then finally, you want to make sure that you work with an experienced estate administration firm like Cody & McCarthy to make sure that the process is as smooth as possible and to help navigate multiple various bumps in the road that you don't know what's going to come up in an estate. So working with an experienced firm is really key to having the probate process go as smoothly as possible.
Can I add just a little bit to that, just because I've been doing this for a lot of years, and I'm sure Shawnee will have something to add to this slide as well. So we get asked the question all the time, right from the get-go, or even when we're doing planning, is, how much does it cost to settle a probate estate? What makes it cost more? And that's really a function of I personally think it's just a function of the number of assets that you're dealing with, and not so much what they are necessarily. I mean, certainly, if you've got 6 3-family real estate or property, and now you've got all these tenants you're dealing with and all these issues, that could be more complex than having 3 bank accounts or 4 bank accounts. But usually the number of assets and gathering the information about all of those and what the next steps are for each one. So simplifying probate can sometimes mean just consolidating. So ahead of time, before someone has passed away, because when it comes down to it, the will-based estate plan is much cheaper than the trust-based estate plan. So you're always going to get people that choose the will-based estate plan just because they don't want to spend a fortune on their estate plan. So that means they're going to go through the probate court process. So certainly if you can help them consolidate assets and take a hard look at what they can do to avoid probate by using some of those beneficiary designations or co-ownerships, if that's appropriate in that case. Second big issue I see that ramps up the cost of estate settlement is people that have spent their entire life, and believe you me, this is my family, although we kind of hang it out more in the open. Most people try to hide their family disputes and the fact that they don't get along, including in the meeting with the estate planning attorney, which is the one person, if you're, other than maybe a therapist, you should be telling your estate planning attorney the details of any animosity or hostile relationships between your children, because one thing we see all the time is the dynamics of the family change when one parent passes and then change again when second parent passes. And I think it's more drastic when the second parent passes, because you had these siblings that had this need to have some interaction with one another, or had at least this shared relationship with the parent, who in some ways kind of still keeps them in line and gives them a reason to kind of get along or have to get along. And it's not true for everybody, but I've seen this over and over again. And then when mom and dad are gone, now you've just got a bunch of individuals that maybe don't like each other at all. And now they feel like they were stuck together for all these years. And man, do siblings hold on to grudges. So sometimes you're dealing with people that are mad about legal issues, like Emily said, like, why am I not getting the brooch and why is she getting it? And they're upset about those dispositive provisions. And okay, you can talk you through that. And is this what they really wanted? And yep, we're going to follow their wishes. But then there are people that are mad because of something that happened 40, 50 years ago, and this is their last chance to have it out with their sibling, because after the settlement of this estate, they're all going their separate ways. It's like the last project they have together. And that is something that we need to know about, particularly if there is somebody, because this happens a lot. There's one sibling that didn't do anything to help mom and dad, but is going to show up when the money starts getting doled out and complain about the spending of all the money. We need to know about that, because we can help you protect against that. And I think people have this habit in their day-to-day life of like sweeping it under the rug or acting like it's a better scenario than it perhaps actually is. But we should be helping you plan for that, because probate litigators, they're not all cut from the same cloth, but there are probate litigators that if someone hires a probate litigator to say, hey, I don't like this provision in this trust, they can come at you pretty hard and all of a sudden try to undo the whole estate plan. And sometimes their strategy is just, I hate that person, I'm going to make them spend all the money that they're inheriting, or just rack up the fees, or slow down the entire process so nothing moves forward. And it's pretty easy to do that, particularly if you have not put together even a will, because Emily was talking about the heirs at law and who has this right to challenge an estate. And when you've got, so the heirs at law are the people that would have received if you did no estate planning. If you put together a will and you left it to different people than that group, everybody's got the right to object. So I had one time where the father had children from a previous relationship, and then he had gotten remarried and had kids from that relationship, and then had no relationship whatsoever with the children from the first marriage, which is sad, but in the end, he wanted to leave everything to his younger children from his new relationship. And he cut out the older sons. They challenged the estate, and their objection, which by the way, they got 60 days to file, because the court gave them an extra 30 days, because every time you ask for an extension with the court, they almost always grant it. So everything gets extended. But they objected and they said, no, my dad came by one time and I helped him mow the lawn. It was just the most ridiculous objection. There was no basis for their objection, but it stalled the entire process. And that was one where, he wasn't a client to set up his will, but if we had known about some of that stuff, you can call it out, address it, make special provisions, and try to avoid having to deal with it after, when the dynamics of the family have changed so much.
Yeah, I think the consolidating the bank accounts thing, all of that was really good, but the consolidating the bank accounts is really good. I think people have a certain error, like if you live through the Depression or like when banks failed, I noticed they'll have like 10 different bank accounts because they have that mentality, you have to like spread out your money in different banks in case one fails kind of thing. So I always see those people of a certain age with tons of bank accounts. So consolidating it into one account can just make it so much easier for your loved ones. Even if we're not going to be the ones doing the work, if your loved one has to go to 10 different banks and get the money and file all this paperwork, it's like just a hassle. It's a lot of time. So it's much easier for your loved one. And then, you know, if you're going to be making unequal distributions to your kids for some reason, making sure that you consult with an attorney about that, to make sure that if there's anything possible that you can do to try to avoid a contest from the kid that's getting the lesser amount for some reason, so that you can kind of head that off. I always recommend families to communicate with each other, with their kids, about like what their decisions are. If there's going to be some reason for like an unequal distribution, sometimes it makes sense. Like maybe one kid went to medical school and and the parents paid for all of that, and they feel like, you know, it's fair to even it out at the end or something. That's totally makes sense. But communication is key. But I find that parents sometimes don't see when their kids don't get along. Like when you're talking about like them not in the meeting, the client isn't always telling us their kids don't like each other. The parents can't see it a lot of times for some reason. Like, because if you ask them, oh, how is the family? How are the kids? Oh, they're great. They always say that. Like very rarely do they say, oh yeah, John and Joey hate each other. Like they never really say that.
Usually, like,
So
I always put myself on like high alert for it, and you almost have to watch for it. And if you sense anything in the consultation with the client that feels like there's a hesitation to a particular question, I always kind of drill down on that, or ask different questions. And then if I feel like people are sweeping it under the rug, you do have to kind of pull it out sometimes. I'll flat out say, it seems like, I see, just talk to me about that. And then we'll talk through it.
Yeah, but it is totally always about something that happened, like you said, 40 years ago when they were like 10, and they like hold on to this stuff. And then, you know, and then they fighting about over this, like really can be fighting over like the pettiest stuff, even if everything's equal. Sometimes people just like fight because, like you said, it's the last hurrah kind of thing. So, you know, there are ways that you can try and get ahead of this if we know that kids don't get along, like not picking them in positions of power together.
Right,
or having like a neutral person as the executor instead of one of the kids and stuff like that.
And we are breaking. Sorry, I was just going to apologize. We're breaking from our slides quite a bit, but I was kind of anticipating this would happen. Is once you start articulating some of these ways to simplify, you start just calling back experience and things you've been through. So hopefully this is helpful to you guys. But go ahead, Emily, because I have a couple other ideas that just popped in my mind.
Like Shani said, people of a certain age, what I've noticed is that the older generations, they really do not like to talk about the disposition of their assets upon passing, or even to talk about their assets at all, like consolidation. So I have found sometimes that in order for the kids to get everything set up to be smooth, a lot of times it is helpful to take advantage of Cody McCarthy's free consultation on estate planning. And then we are able as attorneys to explain to the parents why it's important, how it's going to make life easier, and the pros and cons of everything. So that's, I think, something that I've come across quite a bit, that a lot of
that's a good point, because we will sometimes, if we know going into a meeting like that's an issue, is mom and dad don't see the importance in this. Sometimes if you shift the conversation to, hey, by not doing this, you're going to make my life harder, it just switches it in their mind, like, oh, you know, it's not about me because I won't be here. It's about trying to make it easier. And so a couple other points. One, it kind of follows up something Shani just said, which is if you're going to treat children unevenly, it's good for us to know that. It's nice even if you leave a letter expressing what your intent was, because that can completely stop litigation in its tracks. If you've got written documentation of what the intent was, here's my thinking and why I did this. That I've had clients write letters and used that to prevent and stop litigation, and successfully it works. Because judges care most about the intent of the person that passed away, right? So if you've got the actual proof of that in their own writing, rather than just, I give this to this person, that doesn't tell you why necessarily. So sometimes these letters of intent are really helpful. But loans within the family, I think, are really common and create a big problem. So recently we settled an estate, Emily and I, that is, where some of the children presented these notes that were basically stating that I'm giving you $10,000 or $15,000 and it's an advancement of your inheritance. And then other children had notes that said, this is a loan and you owe money back. And it just was handwritten in some cases, not signed, not dated, not clear. Very, very difficult to layer that into the administration process, because if you've got contentious siblings, you bet everybody's got a different version of that story and what actually happened.
Right. And of course, on this one, we do have contentions still.
Yeah, exactly. Yeah, I know. So it happens. But it's something to think about. Like when you make loans to children, and if you're going to try to call it an advance of inheritance, that's got to be in a will. Like you've got to document that. You've got to talk that through with an attorney, make sure what you actually want to have happen is happening. Another item that would be really helpful, and this is true even of settling trust, is just making a list of what your assets are. Because I think a lot of times people don't realize that wills and trusts will dictate what to do with your property generally. So, I want this percentage to go to this person, or I want to split evenly amongst my kids. Very rarely do you see, okay, with this account, do this, with this account, do this. It's not going to say that. So number one, first question right out of the gate we get from personal representatives and successor trustees is, all right, where's the page in the trust that tells me what's in here, or what am I dealing with? And we have to say, well, there isn't, because we can't police the clients forever to say, oh, you switch from Bank of America to Santander, let us know. They're not going to do that, right? So over time, the assets are changing. So if you want to make things simple, jot it all down. We did a presentation earlier this summer, maybe spring, with Sandra Batra, who is a woman that works on life transition binders, and I'm actually embarrassingly still in the process of making mine. But it's basically this comprehensive binder of information. So it lists all of my assets, all my insurance information, health insurance, disability, life insurance, everything, my BBO number, my bar number for my legal license, everything is in one place. And the idea is, as something happens to me, someone can just flip through that binder and step in and do whatever needs to be done. That's a huge leg up for someone settling an estate, to have that information, because otherwise they're going through like a hunting process of looking through your assets.
We do have one question.
Go ahead. Yep.
No, so we have a question about how much does it cost to create a trust?
So we do fixed fees for our estate plans. So we generally charge about $1,100 per person to do a will plan, which is a will-based plan. That would include power of attorney, all your healthcare documents, plus all of our meeting time with you. Some more complicated wills can be closer to $1,500. And then trusts are from $4,100 to $5,200 generally. We'll fix a fee for you, and it's based on the complexity of the trust provision. So some people will say, I split everything evenly amongst my kids. Some people will say, I have 20 beneficiaries, and if this one's not here, then this is what happens. If this one's not here, this is what happens. It just can get to be more complex. So that's basically what we base it off of. But those are your rough prices.
And then, one thing we didn't mention much earlier in the slides, but like the biggest question I always get when somebody passes away is like when we're going to have the reading of the will. Like people always ask me that, because that's what happens in movies and on TV. But in reality, there is no like formal reading of the will. Although sometimes I think it'd be kind of cool, because on TV someone always faints or something, right?
Unless it's a 100-page trust, you're gonna have some very bored people.
Yeah, but in practice, there's no like formal meeting where you come in to meet with us and we read the will to the family.
I mean, we do walk you through all the like.
Yeah, we do walk you
what
all.
it all means. It's just we're not gonna sit there. No one reads it.
Yeah, like that's like typically would happen in a movie or something that doesn't
yeah.
happen in reality. But everybody
well, I
always
think we should
asks.
be willing to offer that if people want pomp and circumstance.
Yeah,
Why
exactly.
not? Put some donuts out and make it a thing. So if anyone has any more questions, you can submit them within the chat feature. And if not, I wanted to put an email address. I'll put my email address. You can submit them to me and one of us will get back to you for sure. And if you have estate questions or sorry, someone raised their hand and I don't know what that means. If you have a question, just go ahead. Oh, maybe I think I can allow that person to speak, but maybe that was a mistake. The hand is down now. Sorry. Okay, we have another question that was just submitted. So if the person that raised their hand wants to ask a question, just go ahead and submit it via the chat feature and we'll answer it. So we have another question. If an aging parent already has a will set up, but now it's time to create a trust, do you start by reviewing the existing documents to help reduce cost? So generally when you're migrating from a will-based estate plan to a trust-based estate plan, you're going to be getting rid of that will anyway. So what I would say is you certainly, I mean, unless it's the most complex will in the world, which 99.9% of the time it's not, we can really easily get to the provisions that we care about. So I would say bring it to the consultation or email it to us ahead of time. That way, when we're talking to your parent about setting up the trust, if there's decisions that they've already made in the will, like, hey, who do you want settling your affairs? Okay, instead of personal representative, it's going to be the trustee. We can say, hey, this is who you decided on last time you did this. And that can be helpful in minimizing the amount of decisions they have to make in that new meeting. But we would not charge to sit there and review the will, knowing that really they're most likely migrating over to a trust-based estate plan. All right, so no other questions have been submitted. I want to be respectful of everybody's time. You can email us with any questions. And like I said, we offer complimentary consultations. To settle new estates, we don't offer complimentary consultations because we charge a flat fee of $450 to do those initial meetings. And that's because a lot of times we will give you a lot of very useful counsel right out of the gate. Sorry, one more question came in. Do you help aging parents determine how much to set aside in their trust, how much to fund into their trust? So that's a good question because that highlights the difference between different types of trusts. So the revocable trust that Shawnee and Emily were talking about, those are trusts where you're really just trying to avoid probate and maybe get some estate tax savings. And we would want you to put everything into that type of trust because everything should bypass probate. You can't put in qualified retirement accounts like IRAs or 401ks, but you'd have the trust as the beneficiary in most cases. So the idea would be that that type of trust would hold everything. If instead you're talking about an irrevocable trust, and a lot of people do these where now you're not the trustee, you're not going to be able to make changes, and you're not the beneficiary of this trust, and people do that because what they're trying to do is essentially give away assets in a way that doesn't just have them go directly into the name of children or beneficiaries, basically holding them off to the side so they're not counted as your assets in the event that you go to a nursing home. And there you are going to want to analyze what makes sense to actually put into that trust because you don't want to put everything. So you put everything in and you don't have access to that trust, now you don't have access to your assets. So we absolutely do help people determine how much to put in. Sometimes depending on the value of the assets and what they consist of, we will sometimes pull in the financial advisor for this person and ask them to weigh in as well. But we do a lot of that. So yeah, we do help people with that. Shawnee actually does a lot of Medicaid trusts.
Yeah.
All right, so thank you, everyone. Thank you, Emily, for taking the lead on putting together this presentation. And thank you, everyone, for participating. Like I said, you can submit questions to us via email, and I put the phone number 617-472-5151 if you or anyone you know needs to set up a consultation. Take care, and that concludes our session. Thank you so much.
Thank you.